Going on 2 years now, Judge? And we're still talking about it. Again, I digress a little. Public health emergency. Pandemic. Can we at some point in time acknowledge we've moved on to an endemic? God, I hope so. Judge, the emergency rule, again, we have two issues here as it relates to emergency rules. Procedurally, do they pass muster? And substantively, do they pass muster? The governor cannot cloak an administrative agency with any authority to pass rules that aren't provided for by the legislative act that gave rise to the administrative agency. Can't do it. So when we get to it before long, when we're talking about vaccination and testing for their emergency rule, we have a statute that says the Department of Health requires that. People can object. The Department of Public Health can't disregard the law and just write a rule that completely disregards that. They don't have that authority substantively. The governor can't cloak them with that, but we'll get to that. Procedurally, which is where you started this. As the court saw in the Administrative Procedures Act, you have to give facts of what constitutes an emergency. To skip what, Judge? What are they trying to skip with their emergency rules? Due process, 45 days for notice period number 1 for public comment on a proposed rule change. Second notice period for another 45 days for the JCAR, the Joint Committee of Administrative Rulemaking. So 3 months after the proposed rule change, you might be able to put a new rule in place if it passes through the public process and through JCAR. Procedurally, they wiped all that due process away because of an emergency. So think of the irony here, Judge. Every court that we were in front of contemporaneously with what they did was ruling that you can't violate people's due process. So what they do? Create an emergency rule, tries to take it away. Reasons for emergency. I circled it, Judge. These emergency amendments are adopted in response to Governor JB Pritzker's gubernatorial disaster proclamations issued related to COVID-19. Now, we're all intelligent people. I would love for somebody to explain to me how that rises to any factual basis to put this emergency rule in place. Emergency amendments are adopted in response to Governor JB Pritzker's disaster proclamations related to COVID. Judge Trumper, when they said the same thing to her, it never made it through her court because it got transferred here. She was like, COVID's been around with disaster proclamations for 545 days. And somebody's going to tell me that's an emergency? She wasn't convinced.
That's a good point.
Now, my colleague, Ms. Satterley, while she defended it, she at least acknowledged when we argued that issue in front of Judge Trumper that it's no secret that these court cases that we were all involved in probably precipitated these emergency rules. Again, she then went on to defend that she still thought it was nonetheless proper. That's fine. But I didn't have to sit there and listen to 40 minutes of talking about how, well, we can just write something in there and we get broad discretion and the court can't really look at it unless... I'm sitting there listening to that. If we're always going to continue to say these administrative agencies and the governor can do pretty much whatever they want, and the court's oversight is limited, we're going to go on forever with this. We're going to go on forever. So if you read in paragraph 9, Judge, and ask yourself, is there a sufficient factual basis in there for this emergency? The answer is no. Everybody in this room, Judge, knows that these emergencies were promulgated to completely try to cut the courts out of these arguments. For goodness sakes, they took modified quarantine and tried to strip it out of the emergency rule, which was the very basis of which every one of these courts had ruled. You can't do this to people. Even State's Attorney Dan Wright issued a memo on the issue and said, Illinois law vests exclusive authority in the local health department relating to disease control. Local health departments required to coordinate with schools, etc., for policies, plans, procedures. Even the state's attorney's opinion is that the health department has the discretion. I was in a courtroom right down the hallway here in a court where an order was issued requiring a child to wear a mask because they had deemed potentially a public health risk. Due process, right here in this courthouse. Then all of a sudden, we have emergency rules trying to strip that away, trying to say, oh, there is no such thing as exclusion from school anymore. Oh, we're going to pass an emergency rule, 690.361, that says vaccination and testing, etc., is not a quarantine. They can't do that. They can't do that, Judge. Vaccination and testing is specifically protected under 20 ILCS 2305, Part D and Part E. Specifically protected. These emergency rules are a ruse, man. They're all a ruse. Everybody knows it. And to stand here for 30 minutes and try to pretend that it was them exercising discretion because of the ongoing emergency. This emergency's been ongoing, again, better part of 2 years. On September 17th, that was not what precipitated that emergency rule changes. It was not. It was trying to cut the court out of these cases because courts had been ruling. Judge Wellborn, Judge Grunke, Judge Schieffer, Judge Tromper, Chief Judge Jarman were all saying that you can't do this to people without giving them due process. And then what do? We try to throw a rule in to try to strip all of that away. It's